In a medical malpractice case, if during the course of discovery, now you are being questioned at your pretrial deposition, if the defense turns around and says, hey, have you ever brought a lawsuit before? Are you required to answer that question? Does it matter? Does it have anything to do with your current case, whether you brought a lawsuit before? Would you like to know the answers to those questions? Come join me for a walk through the neighborhood as I share with you the answers to those questions. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The short answer, or short answers, are yes, you do have to answer the question about whether you have brought a lawsuit before. Does it matter? The answer is yes, it does matter. Now, why is that? In these civil lawsuits in New York involving accident cases and medical malpractice cases and wrongful death cases, the defense is entitled to learn a lot of information that may have nothing directly to do with the acts of medical malpractice and the injuries you suffered. You should know that your credibility is of the utmost importance in your case, in your civil case. Now, why is that? It's because your entire case rests on whether or not you are believable. You don't ever want to be in a position where now someone is pointing a finger at you and accusing you of telling a half-truth, of saying something that is inaccurate, of saying something that is simply not true. The best thing you can do in your civil lawsuit to help you successfully navigate your case is to tell the truth. During the course of your medical malpractice lawsuit, the defense will have an opportunity to ask you hundreds, if not thousands, of questions during this pretrial process known as a deposition. During the course of being asked all these questions, the defense is going to ask a very simple, very clear-cut yes or no question. Mr. Jones, have you ever been involved in a lawsuit before? Or have you ever brought a lawsuit before? And you're thinking, wait a second. I was involved in a car accident lawsuit 10 years ago that was settled out of court. He doesn't need to know any of that. It's none of his business, and it's got nothing to do with my medical malpractice case. So I'm going to go ahead and answer no, because I think he'll never find out the true answer to that question. Is that a wise move? The answer is absolutely not. Why? Because the defense will already have done a background search on you. They will already know whether or not you have or have not brought a lawsuit before. The defense is asking you that question to verify that you are in fact being totally credible and believable. If you turn around and now say something that is untrue for something that has no bearing whatsoever on the facts of your medical malpractice case, when your case ultimately goes to trial, the defense will ask the judge for a legal instruction to the jury that says, listen, ladies and gentlemen of the jury, if you find that a witness has testified falsely about one thing, it could be a tiny little thing, you, the jury, have the right to throw out and disregard some of this witness's testimony or all of it. So just because you think one case has nothing whatsoever to do with the next case, what the defense attorney is trying to do is to see whether or not you are being honest, whether you are being truthful, whether you can maintain your credibility. And if, in fact, the answer is yes, you have brought a lawsuit before, then your answer absolutely should be yes, I have brought a lawsuit before. And now the attorney will ask some follow-up questions. What type of case was it? Oh, it was a car accident case. How long ago? 10 years ago. And now the defense attorney will also have the ability to ask you questions about the injuries that you claimed in that prior lawsuit. And you might be thinking, that's ridiculous. One has nothing whatsoever to do with the other. That may be entirely true, but the defense attorney doesn't know that yet. And so now you have to explain to him briefly what injuries you claimed in that car accident case, because then he will compare and contrast it to the injuries you are now claiming in the malpractice case. He will want to know what treatment you received from the car accident case and what you needed to do to get better and to recuperate and rehabilitate. And now, he will use that to compare and contrast to the injuries you are claiming in this case, in the malpractice case. And ultimately, the attorney will try and determine which of the injuries you are claiming today are because of your claims that the doctor was careless, as opposed to the injuries that you suffered from your car accident case. So let's say you suffered neck and back injury, and you suffered herniated discs and needed surgery to your spinal cord as a result of the car accident case. But the case you are now bringing against your doctor involves a failure to diagnose, let's say, lung cancer. Clearly, they are two separate and distinct types of claims, but the defense attorney is well within his right to ask you many questions about your prior lawsuit, about the injuries that you suffered in that prior lawsuit, as well as the injuries you are now claiming that were caused by this careless doctor and hospital staff. So don't think for a second that just because one case is unrelated to the other, that you don't have to answer it, or even worse, that you answer it untruthfully. And if you happen to answer that untruthfully, now what you've done is you opened up a huge can of worms that impairs your credibility and could literally sink your case. So why do I share this quick information with you? I share it with you to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if you have not yet started a lawsuit, but are thinking of doing so, and your matter happened in the state of New York, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.